Welcome back to channel. Recent adjudication order passed by ROC Coimbatore regarding delay in filing of MR-1 after appointment of managing director. This clearly shows that even a small delay in filing statutory forms can result in heavy penalties on both the company and officer in default. This video I will discuss what is Form MR-1, legal provisions under Companies Act, facts of this case, penalty imposed by ROC, important compliance. MR-1 is a mandatory e-form filed with MCA for appointment of MD or full-time director and manager. This form is filed pursuant to Section 196 of Companies Act read with Rule 3 of Companies Appointment and Remuneration of Managerial Personnel Rules 2014. So this is company is required to file MR-1 within 60 days from the date of appointment. Failure to file within the prescribed time attract penalties. Legal provision here involved is 196. It deals with the appointment of MD, full-time director or manager. So whenever a company appoints or reappoints a managing director, the prescribed return in the form MR-1 must be filed within 60 days. What happens if no specific penalty exists? In this case, ROC invoked section 450. 450 general penalty, where there is no specific punishment or penalty is provided elsewhere in the act, then section 450 becomes available. Penalty 10,000 ancient penalty and 1,000 per day continuing default. So maximum it can reach up to 2 lakh on the company, 50,000 in officer in default. ROC reproduced this provision in this adjudication order. Here actually what happened is the matter relates to Tambai Modern Spinning Mills Limited. If you see here, the facts, if you come to the facts of the case, here the company appointed one MD effective from 1st April 2025 through board resolution dated 5th March 2025. As per MR-1 should be filed on or before 31 May 2025 because within 60 days. But however, the company filed MR-1 only on 17th June, resulting in a delay. ROC observed another earlier default relating to appointment effective from 1st April 2022. There was also MR-1 delay. Therefore, ROC considered repeated non-compliance. Company admitted the default and stated that if that it was an inadvertent mistake without malified intention. However, ROC said compliance obligation still exists. Delay cannot be ignored merely because there was no malified intention. Company must strictly comply with the statutory timeline. Penalty imposed on the company 62,000 based on the number of days, and MD 50,000, other officer in default 50, another officer in default 50. This is what here we can see 350s and 162. ROC specifically directed that officers should pay penalties from their personal sources. Order is very important. Many companies assume that delay filing like MR-1, DR12, MGT14, PS3 can be regularized merely paying additional fee. Anyway, we are paying additional fee. No, that is not correct. Additional filing fees do not protect the company from adjudication penalties. Practical here, the lesson is maintain compliance calendar. Every company should maintain a detailed track both for board resolutions, due dates, ROC forms, event-based compliances. For MD and full-time director appointments, calculate 60 days immediately. Keep documents ready. File MR-1. Additional fee do not end the liability. MCA accepts the delayed filings with additional fees, but ROC may still initiate adjudication proceedings. So the officers are personal liable. Directors, KMPs, and officers default may face personal penalties. In this case, ROC imposed 50,000 on individually. So on officers, the order states that the appeal can be filed before RD within 60 days from MDJ if company or director wishes. This is important of filing of MR-1. Thank you. We have two channels, RR Corporates, other channel RR Legal Talks. Please do subscribe, hit the bell icon so that you will not miss latest videos. Thank you.